Our topic today is family, finances and final wishes, navigating the intersection of family law and estates. I'm Bridgette Kelly, one of the principals in the family law team here at Howard Andrews, and I'll be hosting today's webinar. So presenting today, we Ivy O'Dwyer, who's an associate in our family law team. Ivy assists our clients in all aspects of family law, including parenting arrangements, property settlements, divorce, family violence intervention orders. We also have Tristan Burke, who's an associate in our wills and estates team. Tristan assists clients with estate planning, estate administration, estate disputes, superannuation disputes, and matters in VCAT administration and guardianship list. Here at Howard Andrews, we understand the value that can be brought to our clients through cross-practice collaboration. And in many of our matters, we consult with our colleagues on issues which may arise requiring the expertise of a lawyer in another practice area. Or upon the conclusion of a matter in one team, we might refer a client to another team for a further issue that needs to be dealt with. Today, we're going to explore some of the common intersections and differences between family law and wills and estates law. When a couple separates, there are legal aspects of separation which must be dealt with, and we often find clients interchangeably contact either our family law team first for advice regarding their separation, or may first contact our wills and estates team to ensure that their estate affairs are in order following a separation. And while there's no right or wrong way to taking the first steps necessary about legal arrangements following a separation, there are many crossover areas and some important aspects of separation which may depend on whether you're in the realm of family law legislation or wills and estates legislation. And today we're going to cover some of those cross-practice areas and give some insight into the appropriate steps clients should take upon separating from their partner or spouse. So the 4 topics we're going to cover today are, firstly, what's considered property, which can be dealt with in family law separation, versus what is capable of being gifted in a will. Then we're going to talk about how property is divided under the Family Law Act and if there's a similar mechanism relevant to wills and estates legislation. We're then going to talk about the difference between separation and divorce, and how does that impact the terms of a will and estate planning documents generally. Then lastly, we're going to talk about if one party dies in the middle of a family law settlement negotiation, what happens if a person changes their will and dies before their property settlement has taken place. Okay, so let's get on to topic 1. So, Ivy, can you please tell us a bit about family law property settlements and how property itself is defined in these situations?
Thanks, Bridgette. Negotiating a family law property settlement is the process of coming to an agreement which divides up the property of the parties and making that agreement legally binding. A separated couple will remain financially tied to each other until they have completed a formal property settlement to cut those ties, or until the relevant limitation period applies.
So, are there any time limits for separated couples to obtain a property settlement?
Yes, married couples can complete a property settlement any time prior to divorcing, but once a married couple have obtained a divorce, a 12-month time limit begins for the property settlement to be completed. For de facto couples, there is a 2-year limitation date from the date of their separation to complete a property settlement. However, it is possible to do a property settlement after 2 years for a de facto couple or after 12 months from the date of divorce for a married couple. So the lapsing of the time period doesn't automatically cut those financial ties.
All right, so Ivy, what is property under the Family Law Act?
Well, the Family Law Act defines property as property to which those parties are, or that party is, as the case may be, entitled, whether in possession or reversion. So not a very straightforward definition. Essentially what it means is that the property pool is comprised of absolutely everything that the parties own as an asset or owe as a debt, whether it may be held in joint names, one party's sole name, or through businesses or trusts. Assets, for example, can include real estate, vehicles, bank accounts, shareholdings, businesses and trusts. Debts can include mortgages, business and personal loans, credit cards, vehicle finances, and so on. The superannuation entitlements of each of the parties are also included in that property pool.
So now we know what property is. What about timing, Ivy? Does it matter when each party's obtained their assets or their debts?
No, it doesn't matter when the assets or debts were accumulated, before, during, or after the relationship. It is still considered to be property, which must form part of the asset pool available for division in a family law property settlement. This also includes assets that have been inherited by one party, and that includes before, during, or after the relationship has ended. Because of this, sometimes it can take quite a lot of negotiating to determine how the property pool is comprised, as well as the value of that property pool. This may especially be of concern where one party has had more financial control in the relationship, or in cases where the parties have kept their finances quite separate during their marriage. The exchange of full and frank financial disclosure documents does assist with that process.
Okay, so now tell us a little bit about pets. Are they considered property under the Family Law Act?
One question that we do get asked quite often is how pets are taken into account for separation. Under the current legislation, pets are considered to be property. Generally, pets will not be considered as an asset in the property pool, and the ownership of a pet following separation should be practically determined between the parties. However, some animals which can be considered to have a monetary value, such as racehorses, livestock, show dogs, animals as part of a breeding business, could all have a value appointed and be included in the property pool. We actually have new legislation that's coming into force in June this year, which essentially codifies how pets have previously been dealt with in the family law space. Household pets have been given a new definition of a companion animal, which means an animal kept by the parties primarily for the purpose of companionship, but does not include assistance animals, animals kept as part of a business, or animals for agricultural purposes. So this new legislation aligns with the previous understanding that your regular household pets, dogs, cats, birds, etc., are treated as property but do not have a value and form part of the pool. But non-companion animals may do so on a case-by-case basis. The factors that will be included in the legislation as to what the court should take into account when considering making an order for the ownership of a companion animal post-separation include who paid for the animal, who is the animal's registered owner, the extent to which each party cared for that animal, the attachment by either party or a child of the relationship to that animal, and any actual or threatened cruelty or abuse by a party towards the companion animal.
So we often do get asked how family law deals with the issue of pets following separation. So it's great to see that this has now been accounted for in the legislation. All right, so now over to you, Tristan. Now that we know how the concept of property works under family law settlements, does the relevant wills and estates legislation take the same approach when determining what is proper property capable of being gifted in a will?
Thanks, Bridgette. Before I go into that explanation, I'll just very briefly explain what a will is and when it comes into effect. A will is a legal document that sets out where you want your property to go when you die, and it also appoints an executor to deal with the assets that you leave behind. And the executor is responsible for settling any debts you might leave and then distributing what's left to the people you've included in your will. So the key takeaway is a will only comes into effect on death, and your executor has no powers until then. Regarding the property that's included as part of a person's estate after they have died, the concept of property in a wills and estates context is more narrow than in family law, and it doesn't take into consideration contributions or anything like that. It mainly looks at how assets are owned and whose names they're in. In Victoria, the Wills Act contains a definition of the property that can be gifted in a will, which includes any person which a person is entitled to at the time of their death, or that their executor becomes entitled to while they're acting in that role. Property itself includes real property like houses and land, and personal property including money, shares, household items and jewellery, vehicles, boats, crypto, and the family pet.
So that definition sounds quite broad as well. Are there any forms of property that can't be gifted in a will?
Yes, there's a few kinds of property that can't be gifted in a will. So unlike family law, property in a wills and estates context does not include assets that are held jointly with another person, assets held by the trustee of a discretionary trust, superannuation, and some type of investment bonds, which are anecdotally becoming quite popular at the moment. So starting with jointly held property, any asset which is jointly held with another person passes to the other joint holders when one of the holders dies through a concept known as survivorship. That's because each asset holder doesn't have their own separate interest in the property. They have a collective joint ownership. For example, if two people are registered on the title for a house, say husband and wife, and one of the parties dies, the surviving holder will automatically be entitled to receive that asset, regardless of what the deceased person's will says. The same concept applies to bank accounts, shareholdings, and anything else that can be owned jointly, which is most assets.
All right, so that's different to family law. What about assets held in a discretionary trust? Can they be gifted?
Yeah, I'll just start by giving people who aren't familiar with discretionary trusts a very basic kind of definition of what they are. So a discretionary trust is essentially a separate structure that creates a legal relationship between someone called a trustee and a group of beneficiaries, often like a family group, and a wider class of people related to them, like, blood relatives, for example. In Victoria, a discretionary trust can exist for up to 80 years, but it can be for a shorter period of time based on the terms of the actual trust document itself, which is called the trust deed. A trust is controlled by a trustee who can be an individual or a company, and their role is to decide essentially which beneficiaries as part of that group receive income and trust assets. The important thing to know about this is that the trustees themselves don't actually own the assets. They just hold them on behalf of that group of beneficiaries. And the beneficiaries themselves don't own the assets either. They only become entitled to an asset when the trustee has actually decided to give them some income or give them an asset from the trust. So since people don't actually own assets held in a discretionary trust, they either only control them or a part of the pool of people who can receive them. You can't directly give away trust assets in your will. But there's another role that exists in a discretionary trust called an appointor. Sometimes it's also called a guardian. And their main role is essentially to remove and replace trustees. In most trust deeds, the appointor can nominate successive appointors in their place on their death. So assuming a person is an appointor of a trust, instead of giving assets in the trust away in their will, what they would do is say who is to control the trust on their death, and that appointor would then maybe appoint themselves as the trustee so they have control of where assets go. So that's how trusts are captured as part of estate planning. I should probably note that although you can't give away assets directly in a will that are held by the trust, it is common for people to put wishes around how they want assets to be dealt with in their will or another document. For example, I want the trustees of the trust after my death to benefit my spouse, and then after my spouse has died, I want them to benefit my children or whatever their wishes are. But because a discretionary trust is discretionary, those wishes are just wishes. They're not binding. So yeah, and the only other thing to note is if the trust owes you any money when you die, so if it owes you any unpaid entitlements that are still in the trust but you're owed, that is an asset that you can control in your will.
And what about superannuation? How's that dealt with?
Superannuation is also held in a trust structure. So it's held by the trustee of a superannuation fund. So the only way to control where your superannuation goes after you've died is to prepare something called a binding death benefit nomination, which all funds have. And you can nominate, for example, that you want your superannuation to be paid to your estate if you die, and then the terms of your will say where it should go. Or you can also nominate dependents directly, which might be your spouse or your children. But if you don't have a binding death benefit nomination in place, the trustee of the superannuation fund will make a decision about where your death benefits go, which is most often to a dependent, unless you don't have any dependents, and then often it's through your will. Death benefits essentially mean any superannuation balance and any life insurance component held as part of the superannuation. So without a binding death benefit nomination in place, a person really has no control over where their superannuation goes. And interestingly, Bridgette, just this week, ASIC released some statistics about binding death benefit nominations as part of their kind of overall investigation into superannuation funds. And the findings in the report are pretty confronting. The report has set out that almost no members at all between 20 and 30 years of age have any form of nomination in place at all, which improves slightly as members reach their 50s and 60s, which is around the time that we find most people come and see us to make their first will. So it seems that how their superannuation's dealt with is kind of discussed maybe around that time. But one of the key issues we've seen in the data that was released is that most people are making a non-binding death benefit nomination, which essentially just acts as a wish and really just leaves you in the same position as you were without one. It's still up to the trustee to decide where superannuation's paid on your death. So if a person wants some control about where their superannuation ends up, they need to make a binding death benefit nomination, which has to be physically signed in front of 2 independent adult witnesses.
All right. So as we can see, there's already some differences in how family law and wills and estate approaches the topic of property, and why there can sometimes be confusion for clients who are having legal assistance or needing legal assistance in both of these areas. So let's take us to the next slide. So, Ivy, now we know how property is defined. Can you tell us a bit about what the court takes into account in determining how an asset pool should be distributed in a family law settlement?
The court considers a number of factors when determining who should get what share of the asset pool. Firstly, they need to look at what are the assets and liabilities of the parties and their value. So that's what we discussed in topic 1, defining that property pool available for division. Secondly, they look at the contributions of each of the parties to the de facto relationship or marriage. Those contributions can be financial and non-financial. And for example, we look at, did one party have more assets at the beginning of the relationship? Did one party make a financial contribution during the relationship outside of their own resources? That, for example, could be if one party received an inheritance or some other windfall of money. Did one party make a non-financial contribution to that asset pool over and above the other? A common example that we hear from clients is that a family member of one of them has completed renovations to a property without payment. So whilst they haven't gifted money to the party's asset pool, they've provided a financial benefit through that contribution. We also look at contributions such as who cared for the dependent children, who was the primary parent, and homemaker for the family. Thirdly, we look at what are the current circumstances and future needs of the parties. So that's looking into the future about what do each of the parties to the relationship or marriage need. We need to consider things such as whether any of the parties are going to have the primary care of dependent children. So children under the age of 18 is what we look at. We also need to consider the parties' age, their health, their income, and also their capacity to earn an income, or whether they need to reskill in order to do so. The fourth and final step that we look at to determine the outcome is a weighting exercise of all of those factors and anything else relevant to the parties. So we need to ideally come to an agreement that's just and equitable between the parties, or fair, and that takes into account all of their circumstances, such as how long the relationship was, as well as the other factors mentioned previously. I'll also briefly note that provided that an outcome is fair between the parties and within a range that the court would approve, it can be documented in a minute of consent order, and then it goes to the court who reviews it, and then if there's no issues, approves it and makes it into a final order, and that final order is binding. However, the parties can reach an agreement that is not fair or just and equitable. They can still have this agreement documented and made binding, and that agreement is called a binding financial agreement. It's basically a private agreement between the parties. It doesn't go to the court to be reviewed and then made into final orders. I won't go into the differences of those agreements today, but there are multiple options that parties have in order to finalise their family law property settlement. However, if parties can't reach agreement by consent as to the division of their assets, either through the consent order process or through a binding financial agreement process, then one of the parties may need to issue court proceedings and have a judge decide that outcome.
All right, thanks, Ivy. So the parties can reach an agreement by consent or the judge can decide. Is that right?
Yeah, that's right.
All right, Tristan, is there a similar process in wills and estates context when the parties separate?
There's not a similar process in the wills and estate space, as a will only becomes relevant after a person's died. But as we'll touch on later, it's really important that once parties do separate, they both update their estate planning documents in case one of them does die or loses mental capacity.
All right, so that brings us on to topic 3. So our next discussion topics are all about the effects of death of a party to a separation on the family law negotiations or proceedings, and how this might affect a party's will and the division of their estate, and what clients can do to mitigate those risks. So Ivy, can you please start us off by explaining the difference between separation and divorce?
Separation is when one or both parties to a relationship or marriage considers that that relationship is at an end. It can also sometimes include when a couple cease living together. However, this is not always the case because parties can be separated whilst living under the same roof. Factors that can help determine a separation may include whether one or both of the parties consider themselves to be separated or act as if they are separated and or other people see the parties as separated. Divorce, on the other hand, is the legal ending of a marriage. It's simply a formal recognition that the marriage has ended. And for example, after you obtain a divorce order, you can remarry after divorce. The granting of a divorce and the act of separation in and of itself does not determine issues of property settlement between the parties. Neither a party choosing to separate or obtaining a divorce order will give rise to creating a formal binding property settlement or to cut those financial ties. Whilst there are limitation periods for couples to make a court application for a family law property settlement, being 2 years to pass following the separation of a de facto couple, and 12 months to pass following a married couple obtaining a divorce, that limitation period is unfortunately not foolproof. As a party can seek leave or permission from the court to file an application for a property settlement out of time, even if that statutory limitation period has passed. Therefore, we always encourage clients to be proactive in obtaining a binding property settlement so that there is certainty that their financial ties have been cut from their former spouse. Practically as well, even if one party is out of time, a family law property settlement may still be required or appropriate in the event that the parties own joint property together, for example, real estate.
Okay, so now that we have that clarification, Tristan, can you explain from a wills and estates perspective, if a client comes to you to update their will, is there a difference between them being separated or divorced? And is there any additional steps you might recommend that they take other than just updating their will?
Yeah, sure. Thanks, Bridgette. There's a big difference between separation and divorce. I'll start with how that affects someone's will. So in Victoria, once a person formally divorces and completes that process, any part of their will that appoints their former spouse in some kind of a role, like an executor, or that gives their former spouse some kind of a gift, is revoked so it no longer has effect. In a will, a divorce essentially acts as if the former spouse has died, so the other clauses in their will apply. And depending on what the rest of the will said, this might mean that their estate's instead paid to children or grandchildren or family or charities or whatever it says. If there's no backup clauses saying who is to be appointed as an executor or how assets are to be paid, though, this can lead to a partial or full intestacy, which can mean that the default beneficiaries set out in the legislation will receive a person's assets. This can lead to very strange outcomes, including people receiving someone's estate who they've never met, like distant relatives who, overseas or whatever, or even the government. A clause can be put in a will to say that if a divorce does take place, any benefit or role given to a former spouse is not revoked. However, if that's what a person wants, for example, if the parties were very amicable and got along really well, but separating without divorce, on the other hand, has absolutely no impact on a will at all. So any roles that a former spouse have been appointed in, like an executor, or any gifts made to them will still have full effect once the separation's taken place. So, for example, say a person was in a de facto relationship and their will gave all of their property to their former partner, and then they've separated, and they didn't update their will and they died, that would have complete effect and their ex would receive their whole estate. So it's really important that people make a new will once a relationship is broken down, regardless if they're married or in some kind of a de facto relationship.
All right. And what if there's still jointly owned property?
Yeah, as mentioned before, a will it can't give away jointly held assets, even when a relationship has broken down. So this means that unless the way that particular asset is changed from jointly held to either individually held or held as tenants in common, any joint property would automatically pass to the other, jointly held spouse, regardless of what the will says. It is possible to change the way assets are held during a person's life, though. For example, they can change the way they hold their home from jointly held to tenants in common. Tenants in common essentially means that each holder has their own separate independent share to the other holders. And this doesn't have to be an equal number. It could reflect the financial contributions people made to buying an asset. For example, one person could own 7 parts out of 10 and the other person could own 3 parts out of 10. And as these parts are kind of individually owned, they can be gifted in someone's will. It's also really common for family law property orders to expressly sever any joint ownership. So if orders are made and a person dies before those orders are carried out, and any joint assets that haven't been dealt with because of the severance in the orders, that can be gifted in a person's will.
So what other documents do you recommend, Tristan, that clients update?
Yeah, so firstly, a really important one is enduring powers of attorney for financial and personal decisions, as well as medical decisions, because neither separation or divorce have any effect at all on those appointments. As a refresher, these documents operate during your lifetime and cease to have any effect after you've died. An enduring power of attorney gives one or more people the power to make financial and personal decisions for you. And you can decide when the document starts. So it can either be once you've signed it, so immediately, or only if you've lost decision-making capacity. And the powers that you can give to your attorneys include where you live, who you see, what you eat, what clothes you wear, and complete access to your assets. So selling your house, accessing your bank account. So they're pretty extraordinary powers that you can give. With medical decisions, the powers that they have only come into effect if you've lost capacity to make those decisions yourself. But the decisions they can make if you've lost capacity include consenting to medical treatment, medical operations, and withdrawing life support. So if you've appointed your former spouse in any of these roles, it's really important that you update them, as once you separate or divorce, they still have full effect. You have to make a new document changing that. The other thing to keep in mind is updating or reviewing any binding death benefit nominations that are in place to your former partner, or if you don't already have a binding death benefit nomination in place, making one. So, because unlike a will, divorce does not automatically revoke a binding death benefit nomination, and neither does separation. It's a bit of a technicality, but even though the binding death benefit nomination itself would still be valid, if you've separated or divorced, your ex might lose their eligibility to actually receive your superannuation death benefits, but it's murky. So the best thing to do is just update the nomination or make one. And the last thing to keep in mind is if there's any companies or trusts that exist, those documents need to be assessed. And if your ex is appointed in some kind of a key role, like that appointer role or like the trustee role, that needs to be assessed and amended if needed. And that also includes looking at documents like shareholder agreements and partnership agreements if there's a business or partnership as part of if either of the spouses are involved in one of those.
Okay. So we can see that while engaging in family law negotiations, given we usually can't indicate any time frame for how long it might take for a property settlement to be reached, it's really important for clients to take positive steps regarding their estate planning. Okay, this now leads into our last couple of questions. So firstly, Ivy, can you tell us a bit about, from a family law perspective, what happens following a separation if one of the parties die?
Something very important to note is that the Federal Circuit and Family Court only has jurisdiction to make final property orders at the time when the application was filed, that both parties to the relevant marriage or de facto relationship were alive. This means that neither a consent order application or an application to commence court proceedings can be filed with the court if one party dies. This means if there is a potential risk to one party passing away, the only way to guarantee that there will be a family law financial settlement is to issue court proceedings for final orders in the court. This is because when there are already property proceedings before the court and a party to those proceedings then dies, the proceedings may still be continued by or against the personal representative of the deceased person, which is usually the executor of the deceased person's estate. The court will generally allow a legal personal representative to be substituted in the proceedings of the deceased person if the court's of the opinion that, firstly, it would have made an order with respect to property if the deceased party had not died, and secondly, notwithstanding the death of a party, that it's still appropriate to make an order with respect to property.
Okay, then, so what would you recommend, Ivy, to a client if they or their former spouse was unwell doing a property settlement?
If one of the parties was unwell, such as they were very ill, that they were hospitalised with a life-threatening condition, have a terminal diagnosis, were to undertake surgery which had a risk factor of death, or even if they're elderly and have a high risk of passing from natural causes, I would advise them that it's prudent to issue an application to the court if they did want to have a family law property settlement. It's important to note that once a party passes away, the order that the court ultimately makes may be different than if that party had not died, largely because the deceased person will no longer have any future needs factors to be taken into consideration. As we discussed earlier, the future needs factors include, for example, the health and well-being of each party. And if one party has died, then they don't have any future needs to be considered by the court. Notably, also, spousal maintenance proceedings cannot be continued against a deceased person, and any existing spousal maintenance orders stop when a person dies.
Okay, thanks, Ivy. So that really highlights the importance of taking into account the current health of parties when negotiating a family law settlement and when considering how long it may take to reach an agreement. And although we generally try our best to avoid commencing in court, it may be in the client's best interest to do so to ensure they can obtain a property settlement. Okay, so Tristan, can you explain what would happen if a person died before their family law property proceedings were commenced and they had changed their will to exclude their partner? Does that new or former partner now miss out? Oh, you're on mute, sorry.
You think I would have got better after 5 years of COVID? This is a unique one, Bridgette, but it does occur from time to time. The starting point in Victoria is that only certain people can make a claim against a person's estate if they're unhappy with the terms of what their will says. And those people who are entitled to make a claim are called eligible persons. In this situation, if the deceased spouse had updated their will before they died to exclude their spouse or former spouse, and before they died, family law property settlement proceedings were not commenced, and no binding property settlement had been put in place at all, their spouse or former spouse could potentially make a claim against their estate. So they might not miss out entirely. Depending on a few different factors, the spouse's claim could be for the amount they would have received if they did do a property settlement while the other person was alive, but possibly for even more. It's important to know that if a former spouse couldn't start proceedings under the Family Law Act, say due to missing some of those time limits that Ivy mentioned before, they're no longer considered an eligible person to make a claim. But there's quite a few categories in the legislation, and the court has the power to permit claims where time limits have passed in some cases. So it really does depend on the specific situation. In addition to the dispute about the estate, though, there's also possible issues regarding the payment of superannuation death benefits if there's no death benefit nomination in place, which we discussed earlier. There can also be fights over self-managed super funds, control of discretionary trusts, companies, and all of those are separate legal disputes not involving the estate. So for this reason, it's really important that people get advice about divorcing, entering into a property settlement and updating their will once separation has taken place or once they no longer wish to benefit their spouse or their former spouse.
Okay, so that's the key takeaways are that if you separate, update your will, your powers of attorney and binding death nominations. But remember, you also need to formalise your family law property settlement as well and make sure that it's binding. So this is a key to avoiding claims against your estate. All right, we're going to get onto a dilemma now, Bob's dilemma. We want to leave you with a sort of nightmare fuel about what could happen if you do not take active steps in your family law and wills and estates matters. So please meet Bob. Sorry, I got a bit of background noise. I'm not sure if you can hear it. Got lots of fire engines going past. Please meet Bob. So Bob remarried for the second time at age 75 to a woman he met at the golf club, and her name was Marie. It was a whirlwind romance that started on the 9th hole at their local club, and a few months later, they got married. Bob has 5 children from his previous marriage to Barbara, whom he wants to inherit his $20 million fortune one day, which is a mix of approximately $10 million in self-managed super fund and $10 million in other assets. Unfortunately, 1 year after Bob and Marie married, they separate. Bob and Marie have a handshake agreement that he will pay to her $100,000 and they'll call it even. Bob and Marie implement this agreement between themselves. Bob pays the money. Bob doesn't bother to divorce Marie or obtain a binding financial property settlement because he hates life admin and he thinks lawyers are a waste of money. Plus, he thinks he's quite healthy for his age and he'll get around at some stage to updating his will. 1 year later, Bob dies. Poor Bob. When Bob's 5 children go to administer his estate, they find out he didn't have a valid will. They also have received a letter that they don't think sounds quite right from Marie's lawyer stating that Marie wants 50% of Bob's estate and that she's going to apply for a letters of administration. They are very confused and upset by this. Tristan, can Marie really make a claim against Bob's estate? She's already received $100,000.
Yeah, look, unfortunately for Bob's children, as Bob didn't have a valid will, the legislation in Victoria says that Marie, as Bob's surviving spouse, she'll get a statutory legacy of approximately $560,000, all of Bob's personal items, and then 50% of whatever's left from Bob's estate. And then the other 50% would be paid to Bob's children from his earlier relationship. And this is all without Marie needing to make any kind of claim whatsoever. That's the default.
So 560,000 is a specific number. What's that all about, Tristan?
That comes from what's called a statutory legacy, which is an amount that's indexed every year, provided in the law to someone's surviving spouse where they've got children from an earlier relationship. And this is where there's no will in place, like Bob's situation. If the value of the estate is less than the statutory legacy, so for example, if it's $500,000, then the spouse would get everything. If the value of the estate is over the statutory legacy amount, so over $560,000 in 2024 to 2025, the spouse would get that amount, the statutory legacy, plus half of whatever's left over. And this amount increases year on year by quite a lot. Like in 2018, it was $460,000. So it does go up quite a bit.
Okay. And what about who deals with Bob's estate? Who would be responsible for that?
Yeah, so in this case, Marie would be entitled to be appointed as Bob's administrator, which is the equivalent of an executor where there's no valid will, because Marie is getting the largest share of Bob's estate. So that gives her the right to apply, essentially. And what she would be doing is she would be applying to the court for letters of administration, which is similar to probate, as some people might be familiar with, which would give her essentially control over the whole process.
So that's not a great outcome for Bob's children. Can they make a claim against Bob's estate for what they say is their fair share?
Yeah, look, as they're Bob's children, they are considered eligible people to make a claim. Children are eligible to make a claim against someone's estate. It's not easy. And if any of Bob's children are in a poor financial situation, if there's some other reason that existed that meant that Bob should have provided more for that particular child, maybe more to them than Marie, they may have a stronger claim, especially compared to some of the other siblings. But making a claim against an estate can be really expensive and a long process, which can be avoided with some estate planning. And it's also important not to underestimate the kind of emotional and psychological costs involved in disputing a will.
Okay, it seems like this all could have been avoided with some pesky life admin undertaken by Bob. Ivy, from a family law perspective, what would you recommend?
Well, my recommendation first and foremost would have been, of course, when Bob was still alive, would be to obtain a binding family law property settlement with Marie so that their financial ties would have been cut. I also would have recommended to Bob, given his age and wealth, to obtain a divorce as soon as possible. If Bob had known that he was unwell, my advice to him would have been to urgently finalise his property settlement matter to obtain a binding agreement. And if Bob and Marie could not decide on their settlement, then my advice would be that he urgently issue a court application in the Federal Circuit and Family Court to ensure that proceedings were commenced prior to his death. Unlike wills and estates law, there's no default framework for dividing assets in family law. It may well have been that from a family law perspective, Marie receiving $560,000 plus half of Bob's assets was not fair and equitable. But regardless, if Marie and Bob had formalised their property settlement, then the entitlement of Marie would have been quantified at that $100,000. And importantly, that agreement would have been binding. My other advice would have been, given Bob's circumstances, that he had accumulated substantial wealth, and that this was a second marriage later on in life, he could have also considered entering into a relationship agreement with Marie while they were together. That relationship agreement can set out what would happen if the parties did separate and how those assets would have been divided, similar to a prenup style agreement to protect Bob's assets. Unfortunately, with Bob's death and no binding property settlement or divorce, then the division of assets falls into Tristan's area of expertise and wills and estates law.
So, Tristan, we mentioned that Bob had about $10 million in superannuation. What would have happened to that?
Yeah, Bridgette, things get even worse for Bob's children at this point. Unsurprisingly, Bob never made one of those binding death benefit nominations that we talked about earlier. And under the terms of the trust deed for Bob's superannuation fund, Marie would end up in control of managing the fund as Bob's administrator. as a spouse, she's eligible to receive Bob's super, and because she's in control, she would most likely decide to pay those benefits to herself. So she'd, possibly get the whole 10 million. Unlike a will, there's very limited ability for Bob's children to challenge this. So yeah, look, Bob's children probably won't see a cent of Bob's superannuation death benefits.
So things would have been different if Bob had made that binding death nomination?
Yeah, that's right. So Bob could have made a binding death benefit nomination in favour of his children before he died, provided the nomination was validly made and executed. Then, yeah, if he made it in favour of his children, they would have received his death benefits, and it would have been Marie who would have missed out. In that case, his children would most likely have to pay some tax on what they received. However, that's a far better outcome than just completely missing out on any of the benefits.
So is it possible that Marie and Bob's children could have come to some arrangement to resolve this dispute outside court?
Yeah, pretty much any legal dispute can be resolved out of court by negotiating between the parties, but that's all based on Marie feeling so obliged.
All right, interesting. Poor Bob's children. All right, we've got a couple of questions. So the first one is, if a property is only in one spouse's name for asset protection, for, say, business structures, etc., is this irrelevant in a divorce and financial settlement?
Great question. So in terms of a family law property settlement, the assets that are included in the pool are included regardless of whose name that they're in. So often parties will have assets just in one spouse's name for that asset protection purpose, but that does get added into the pool. So basically everything that either party owns and owes is added into that asset pool and can be divided.
Great. All right, there's another question here. Please send any now that you might like to ask if you haven't already. For the purposes of restructuring your will, is a family home that's held by one spouse, is it still possible to change the ownership to tenants in common without incurring stamp duty?
Yeah, good question. Speak to your accountant or financial advisor. No, come and see me. It depends. I think there are some concessions when you restructure from spouses, but it does depend on a few things. Concessions can apply, or exemptions can apply, but yeah, we just need to get some kind of complementary advice as part of the overall structuring.
Mm-hmm. And a question here, what makes a valid will?
What makes a valid will? Okay, well,
Yes.
In Victoria, you need to, ideally you appoint an executor, but the lack of an executor doesn't necessarily make a will invalid. It needs to kind of say where your assets should go with some certainty and specificity. It needs to be signed by the person making the will, and it needs to be witnessed in front of two people. And the original will needs to be available after you've died. You can't just have a copy and then delete destroy the original. So there's all kinds of bits inside the will that are important about drafting and technicalities, but for a will to kind of the starting point, needs to be signed and witnessed. Ideally appoints an executor and disposes of all of your assets.
All right, there's a question here. Does divorce invalidate a will?
Not the whole will. Not the whole will. Only the parts that kind of give the former spouse any kind of benefit. So if let's say you've left your house to your spouse and everything else to your kids, and then you divorce from your spouse, the gift to the spouse of the house is that's too rhymey. Sorry. The gift of the house to the spouse, that is essentially cancelled and no longer applies. So that would fall into the balance of your estate and be divided between your children. And if you'd appointed them as your executor, that's invalid, and any backup executors are appointed. That's how that works. Again, separation doesn't have that same effect. If you've separated, the will says what the will says.
Okay. One for you, Ivy. If a partner to a de facto relationship owns a house outright, assuming that means there's no mortgage, and the other partner pays them rent, what is the situation? Should they split up or the house owner dies?
Great question. So I won't deal with the death portion of it, but in relation to that situation, so it really depends. Being in a de facto relationship, and just to briefly, a de facto relationship is generally when two parties have been living together for 2 years or more, or they make contributions to joint assets, or they have a child. That's sort of very broad brush for what is a de facto relationship. But in those circumstances, if one party had an unencumbered home, then that would be considered to be an initial financial contribution. The weighting of contributions does deteriorate over time. So, for example, if this de facto couple separated after 30 years, well, the contribution that they had at the start of the relationship would have depreciated in the family law context over time. You don't get dollar for dollar back on the contributions that you had. In terms of paying rent to your de facto spouse, in a family law context, generally the court doesn't look at individual transactions between the parties. They look at it as a whole. For example, one party might be paying a mortgage and the other party might be paying outgoings. So the fact that the parties themselves at the start of the relationship may have classified as one de facto spouse paying rent to the other, that doesn't necessarily mean that that's a protection for the spouse with the property. It would still be included in the asset pool available for division. They would likely get a contribution weighting factor for that, but that depends on, a number of things.
All right. Did you want to answer, Tristan, what would happen if the homeowner dies in that context?
I think sorry, Bridgette, my audio just cut out a little bit through that. I just missed the first part of the question.
So
I'm sorry.
The same scenario, but if the homeowner dies, what would happen?
I didn't even hear the first part of the thing. My audio just totally cut out. I'm so sorry.
So in the scenario where someone is living together in a de facto relationship,
Yep.
And the homeowner dies, who is owning that property outright,
Yeah, and
would the remaining de facto partner have any claim in relation to that house?
Yeah, in this situation, is there a will in place? Does the will say what happens to the home or not? There's no will.
No, that's not in there. Assume no.
Yeah, assume no. Assume no, and they're in a de facto partnership. Then yeah, if there's let's say there's no children from a prior relationship, then everything would go to that spouse, including the house. If there was children from a prior relationship and they were a blended family, as we talked about before, the spouse would get the statutory legacy plus half of the balance of the estate. So it depends on what's in the estate. But yeah, look, if let's say there was some fight about who gets the house, and how they're chopping up the value of the estate. Depending on how long they were together, I'd say that de facto spouse has a pretty good claim to stay in the house and stay there. Yeah, but it depends.
Yeah. All right. If there's no signed binding death nomination, does the super benefits go directly to the person's estate, and is it distributed in accordance with whatever's written in the will?
Yeah, that's a great question. Most funds, no, it doesn't automatically get paid to the estate. The purpose of superannuation is first and foremost to kind of provide for a member's beneficiary, like a member's dependents on their death. So most super funds will firstly try and determine if there's any dependents who survive a member. That might be a spouse, children, other financial dependents who exist. If none of those people exist, then in that case, it's common for it to be paid to the estate. But that's not the automatic position. Some funds do pay to the estate if there's no binding nomination in place, but that's much less common.
Yep. All right. We've probably got time for another one or two questions. This one is regarding a financial settlement. If one of the parties who largely controls finances is being dishonest in their representation of their assets, what options does the other party have to challenge this?
Great question. And there's a couple of answers to that. So if you're in family law property settlement negotiations, both parties do have an obligation to make full and frank financial disclosure to each other, and they must disclose documents that are in their possession or control. So for example, you could ask for financial statements for somebody's business, etc. If in those negotiations someone is being dishonest and not forthcoming, then it may be that a court application is required, and part of that you would be seeking orders from the court for that specific financial disclosure. If they were still not complying with their disclosure obligations, you could subpoena those documents. Again, you'd have to be in court for that. If there was a scenario where parties do negotiate a financial settlement between them and they get a consent order, so they're not going through that litigated court process, if they find out after that consent order has been made into a final order that one party was hiding assets or being dishonest, that is one of the situations where it can potentially open up a consent order. So to open up the matter again, because you didn't have all of the information that you required, especially if it was significant. So there certainly are options. Obviously, we try to avoid court where we can, but sometimes that is the best avenue to get that information if someone is being dishonest.
Great. All right. Well, that pretty much brings us up to our hour seminar. So thank you for joining us for our webinar today on family finances and final wishes, navigating the intersection of family law and estates. We appreciate the time you've taken to be part of this session and hope that you've found some valuable insights. If you've got any further questions or would like any other resources, feel free to reach out to us. We'd love to hear your feedback and also continue the conversation. And please stay tuned for future webinars and updates, and we look forward to connecting with you again soon. Have a great day, everyone.
Thanks, everyone.
Thanks.